Good morning and welcome to PV Legal's daily newsletter. What if I told you that a routine FIR about a job for bribe fraud has just produced the most important ruling on constitutional protocol that India has seen in 75 years? Not on GST, not on customs, not on PMLA. On 2 letters, an apostrophe, and the word Hon'ble. The case is Harshit Sharma and 2 others versus State of UP and 2 others before the Division Bench of Justice J.J. Munir and Justice Tarun Saxena of the Allahabad High Court, decided on April 30th, 2026. At its heart, this petition was a routine quashing matter. But what the bench noticed in the FIR changed everything. The FIR named a sitting member of parliament and former union minister, Shri Anurag Thakur, in its narrative, not as an accused, but as someone whose name had allegedly been misused to collect money. Standard FIR language, except the police, faithfully copying the complainant's Hindi version, referred to him simply as Anurag Thakur, no Hon'ble. At one point, not even Mr., just the bare name. The bench noticed, and the bench was not pleased. The court directed the additional Chief Secretary, Home Government of Uttar Pradesh, one of the most senior civil servants in India's most populous state, to personally file an affidavit explaining the omission. The SSP Mathura received directions for a preliminary inquiry within 48 hours. The central question the court confronted was one that no statute, no constitutional provision, and no government circular had ever answered. Who, in the Republic of India, is legally entitled to the prefix Hon'ble? There is no law on this. The Constitution does not mention it. The Lok Sabha rules are silent. The Central Secretariat Manual says nothing. The honorific has survived for 75 years on sheer institutional memory, a colonial inheritance that nobody ever codified. The bench supplied the missing rule. It held, clearly and for the first time, that Hon'ble belongs to constitutional functionaries who exercise sovereign functions of the 3 organs of government. Ministers, members of parliament, members of state legislatures, speakers, chairmen and judges of the Supreme Court and the High Courts are entitled. Personal disgruntlement, the court said, or familiarity with a family, cannot permit any author of any communication to refer to a sovereign functionary without the honorific. And on the other side of the line, civil servants, however senior, however powerful, are not entitled. Not the cabinet secretary, not the additional chief secretary, not the commissioner of customs. The prefix is for those who hold sovereign constitutional office, not for those who serve the constitutional machine. For practitioners, the implications are immediate. Every FIR, every charge sheet, every government affidavit that mentions a sitting minister, MP, MLA, or High Court judge must carry the prefix Hon'ble, inserted by the police even if the complainant omitted it. And conversely, civil servants styling themselves Hon'ble in their official communications should stop immediately. The Allahabad High Court has done in one order what Parliament failed to do in 75 years, written the rule down. For the full legal analysis, serious and I confess slightly entertaining, subscribe to PV Legal's daily newsletter. This is your host, signing off for PV Legal's daily newsletter. Stay informed, stay vigilant. Good day.